Hello, welcome to Land Title Talk, where we encourage you to text in your questions or comments at 904-501-4481, 904-501-4481. We will try to get them on the air and talk about those questions or comments. Also, you can email us your questions or comments at that's not my email. Stephen, Stephen, at golandtitle.com, GOLENDTITLE.com. So, I'm Steve Collins from Land Title. We have Rusty from the law office of J. Russell Collins, and then we have Julie from Land Title of America. We appreciate you being here. Rusty.
Yes, sir.
What's going on in your world?
Nothing I can talk about right today. I got lots of things in the wind, and hopefully we'll have some fun to talk about.
I want to talk about ladybird deeds. So we talked about that briefly. We were talking about, and you have to help me with the specifics again. All I remember is that I was uptight about it, and I wish I would have been more specific on the questions. But it had to do with where you do a ladybird deed, and mom gives the directive to two children, in this case, two sons, but one of the son dies before the mom. So, in my opinion, by virtue of that, only one of the sons inherit the property. But before we get into the details of that, explain to everyone what is a ladybird deed. I know we've talked about it before, but let's talk about it again real quickly.
A ladybird deed is a special type of life estate deed where instead of having it to where if I deed my property to you, Stephen, and I retain a life estate, you get a vested remainder interest. I have the life interest. And when I die, it's yours. But if I need to do something, refinance, maybe I decide I need to get my money out of it. And there's also certain duties that come with that. I have a duty to take care of like the interest payments, to pay the taxes, because those are expenses of ownership, of possession and ownership.
Right.
You would have if there was a mortgage, you'd have the duty to pay for capital improvements or to pay the principal part of a mortgage, because that's what reduces the balance. So those duties are
but you as the life tenant can't do anything without the remainder.
I can't change my mind, or I can't refinance or sell the property.
Well, you can if you get me to join in.
Right.
If we're using the example of you being the life tenant, I'm the remainder man. On a normal life estate deed, you give me the deed, I'm the remainder man. I technically, I guess.
You don't own it until I'm dead.
Yes, but you can't do any. Oh, but you can't do anything without my consent. Or with my joinder.
I could sell the property to Julie, but when I die, it goes to you.
Okay.
If I can talk her into it.
So it's just you have a life interest, and you can convey that, you can mortgage it, but it's only as good as you're living.
Right. And
if you conveyed it to Julie, and then Julie conveyed it to somebody else, when you die, that doesn't matter. It comes back to me.
That's right.
That's a normal life estate deed that we're accustomed to.
Right.
Or you just get me to join in on the deed. Mm-hmm. But you can't do it independently of me. We become sort of tied at the hip because I, as the remainderman,
you have a vested interest.
I have a vested interest, and if I convey my interest to Julie, I have to get you. Otherwise, Julie's subject to your interest while you're living.
Right. Right. Now, a ladybird life estate or an enhanced life estate, the ladybird language came from the person who made this popular, using Lady Bird and Linda Bird Johnson as the example. That's the only tie it has to that word ladybird. It's also called an enhanced life estate. And the enhancement is, I deed the property to you when I die, you get a vested remainder, but that remainder is subject to divestment. And I control the divestment. If I change my mind, I can do a deed to myself and terminate your life estate.
Without notice to me.
Yeah, you don't have to know. I don't need your permission. I don't even have to give you notice.
It's an advance directive is really what it is.
It is. It's like a will.
It's an advance directive, yes.
It's just easier because you don't have to probate anything.
Right.
However, that you can't use it to get around homestead laws. Okay,
for example,
if I have a minor child.
Oh, if you had a minor child, and you gave me a ladybird deed, you die, the minor kid's not going to be excluded.
That's correct.
Wow.
Okay. And if I'm married and my wife doesn't own it, I can't. Well, let's say it's not where I live. Okay. If I'm married.
No, stick with where we live because that.
Well, I have to have my wife join in on the conveyance.
Well, that I get. I don't think a minor kid has a say. I think you're wrong.
What do you mean you don't think a minor kid has a say? A minor kid doesn't even have to be born yet for homestead rights to attach.
I get that, Rusty, but when you do a deed, if you convey a property and you have a minor kid living at home,
right,
and you sell that property to Julie, there's no reason to have the minor kid's interest at play here.
That's exactly right.
But
what's different here?
What's different is in this case is that you are giving an advance directive,
Okay.
I guess.
If I give you $5,000 in cash, it's yours, right?
Right.
You can do whatever you want with it.
Okay.
I can't really take it back.
With the ladybird deed, you've not given me anything yet but a directive.
Well, it's a interest in real estate subject to divestment.
Okay.
Okay, and you don't have any control over the divestment. Also, you don't have any duties either.
But so with a minor child, you do a ladybird deed,
Mm-hmm.
then
You can't use this tool or even a trust to get around what you can't do otherwise.
wow.
Okay? That gift, is that a completed gift?
Not until the passing.
Not until I can't take it back.
Right.
It's not a completed gift. So it's subject to divestment. And again, remember, we have our homestead rules for minor kids for a reason. We don't want people to get around those things.
You know, we've got.
You can't use a trust to do that either.
But listen, we have blended families, Rusty,
Yes, we do.
with minor kids.
That's right.
And they do ladybird deeds
They
to
do.
help the husband and wife would do a ladybird deed.
Not with the help of a lawyer. And not the help of the lawyer who knew what was going on.
Well, I don't know if lawyers all know this, but I mean, I would hope that they would. I didn't know this. Or maybe it's watch one of my other shows. Maybe you said this on the show before. I don't remember.
Look,
you have a blended family.
We talked about a lady who didn't know about her father's unborn child when he died.
Right.
Okay, and they
Well,
clawed
judge
everything
signed
back.
off. Yes, right.
Yeah. And she became liable to an underwriter for a conveyance. Okay, the child wasn't even born yet and had rights.
The ladybird deed does not work.
It's not a workaround for homestead.
Wow. Okay.
Okay. Ideally,
Now, if you
there
have
are
adult
none.
children, that's not going to be it's going to be a moot point. But if you have a spouse,
Right.
like, okay, let's change it up a little bit. I have a spouse, but I have other children. And what I do is I don't want her and her kids getting the property. I own the property. She lives there. Okay. So what I do,
You better give her a life estate.
well, what if she's joined on a deed, though? That doesn't matter, right?
I would probably, then she would have it till she dies, wouldn't she?
Well, but hold on. If
Without
me
more.
if me and my spouse,
Mm-hmm.
it's homestead property, so I do a deed
Right.
to my 5 children to circumvent her and her kids, minor or whatever, doesn't matter. I want my kids to get the house when I die. She joins in on that deed and signs it with me.
There needs to be some language that says that she's.
She doesn't have a life estate. She's willing to move out.
Then it needs to say that.
Wow.
Okay. Or you need some kind of a nuptial agreement that says it. You can contract.
So the
around
deed, her just signing a deed to the kids, joining as a
it,
joinder.
not without more. Okay. We have some rules for homestead for a very good reason. Okay, it's to protect the home and the spouse and the minor children. So you got to understand, if you had other property, let's say this was investment property.
Well, investment property is easy.
But here,
I mean, we're not, because you can do that. You can do whatever you
about
want.
homestead.
Right.
Okay.
Right.
If you do not have enough assets in your estate, Okay. You cannot, without a contract that says otherwise, you cannot divest your spouse of an inheritance. Your spouse is entitled to at least 30%. If you've done something that makes it not that, she's still entitled, or the spouse is still entitled to 30%.
Doesn't matter about the Ladybird deed.
No.
Okay.
Because that's not a completed gift.
Interesting.
If you have life insurance, okay, and you make your kids the people that get the life insurance, and you don't have enough leftover assets to cover that 30% that goes to your spouse, remember, unless it's irrevocable, unless you can't change the beneficiaries, okay, unless that's the case, it's not a completed gift, the spouse still gets 30%. This is why you shouldn't be doing this stuff without counsel, because there's those
nuances matter.
Yeah, it doesn't matter till it does. Okay, but it's going to matter.
They're doing these things to circumvent these problems, and they're not going to circumvent the problems. They're going to have the problems.
Okay, there was an estate that was done. You know a little bit about it because you became the successor trustee when the person became incompetent. That. Okay,
yeah, my knowledge.
Okay, and
hello, you're a trustee. Oh, okay. Thank you very much. I didn't even know it.
Then
sign these papers.
There was life insurance and some other stuff. Because the spouse was not getting 30% of the estate, or at least 30%, she got 30%. It came from insurance or whatever else.
Right.
Okay.
And there was a lawsuit to enforce that.
Well, yeah, it became part of probate and a bunch of other things. But yeah, so they had to make a deal to make it, because she was right, and then she died in the middle of it too.
Yeah, that's right. That was so weird.
And then the kids took her place. But again, everything vested.
Yeah. That's crazy.
Now, with
let's talk about the individual, the mom in this case, who, in trying to make sure that she doesn't have probate, she does a Ladybird deed to her two sons.
Right.
And before she dies, one of the sons die.
Right. So, and so here's the analysis.
Well, here's what I want to first put myself out there.
Okay.
What I think. And shooting from the hip, I mean, I guess if they're joint tenants right survivorship, it's a moot point.
If it's joint tenants with right
survivorship, but if it's not, if they're tenants in common, it's an advanced directive. I guess it goes to his heirs, right? The son who died.
Let's do the analysis.
All right, do the analysis.
So first of all, is the deed delivered?
Well, the deed is delivered. Yes.
Okay. Recording is presumptive delivery. Right. Okay. And so that's first thing. So we have a completed transaction. So at the time that deed is delivered, and really we because it's a Ladybird deed, recording is our trigger for that. Okay. If you record it, it's the rule that you have to record a Ladybird deed. You can't have it sitting in a desk drawer.
Oh, really?
Yeah. If it's not recorded, it doesn't work.
Interesting.
Now, if you had a quick claim deed, a top drawer quick claim deed,
even a warranty deed,
or warranty deed, whatever, a top drawer conveyance. Okay, if you can,
which by the way is heavily discouraged.
Yes,
please don't do that. Okay. Please record your documents.
So, if that was the case, if you could show that it was delivered, or if nobody challenged delivery, it'd be good. Okay, even though it's not recorded.
You're talking about quick claim deeds and warranty deeds. As long as it's delivered, title pass, whether or not it's recorded, we just have a notice issue.
That's right.
Right.
Now,
but with Ladybird deeds, on the other hand, has to be recorded, or notice is not considered.
Well, right. Because of the kind of conveyance it is, you need to have proof of the delivery, which would be the recording.
Wow. Okay,
that's number one. And it might be because a lot of times the kids don't even know mom and dad did it, or mom did it.
That's a good point. Mom and dad's, I mean, we actually been involved in one of those, where an individual came in, did a life Ladybird deed to an individual that had no idea they were doing it.
Right.
Yeah.
And believe me, I encourage it heavily everywhere I speak about probate type things. Now, so that is a complete, so that person, is that person vested with an interest in real estate?
The person who died?
Yeah.
Well, I mean, it's delivered. Even though it has...
That's a yes or no question.
I know, but I'm not so
Okay,
ready.
so you're.
I
doing
mean,
the
I've
analysis.
already taken a stance, and that is yes,
Mm.
his heirs get.
Okay.
Yeah.
So, and I know what the answer is, but let's see how we get there so that we understand why.
Okay.
Okay. So that is a vested interest. It is subject to divestment.
Right.
Was it ever
Mom
divested?
can still change
Right.
her mind.
Right. It's a vested interest subject to divestment. Now,
Right.
could mom have, after the son had died, could mom have done a new ladybird deed or changed her mind and canceled that deed?
Yes.
Right, because the
Yes,
the drop
she has
dead
that right
date
to do it.
is when she drops dead. Okay,
Drop dead
the
date.
drop date,
Literal, the literal meaning of the word,
Drop
the
dead.
drop dead date.
Yes.
for changing is when she drops dead.
Right.
Okay,
Not funny.
sure it is.
That's not.
Now,
It's morbid humor.
It's morbid humor.
so
Which
and I
he
warn
has.
people about
Oh,
that
yes.
all the time. I tell people I'm cavalier about death.
Yeah.
Okay, so she doesn't change her mind. That was a vested interest. He just gets to use it later, right?
Right, and which is interesting. If I thought about it, I would have realized this. But the two brothers can't convey to each other their interest. Hey, we know mom did this ladybird deed, so I'm going to give you a quitclaim deed to my interest because it hasn't been conveyed. Now he's
no,
thinking,
it's an interest
and
that's
see,
subject to divestment.
so maybe there is an interest there that you could quitclaim.
Right, but it can be canceled by mom at any time.
I get it, but
So if they deed it to-
so if which I've never thought of, I'm so stuck, Rusty, on the advance directive. This deed is not effective until they die. No,
But it
that's
is a
not
vested
true.
interest in
It
real
is a
estate.
vested interest that can be voided.
Right.
That's I've been thinking about this wrong. It is a vested interest that can be voided.
Well, yeah.
Okay,
You can be divested of it. I don't like
a
to say-
vested interest that can be divested.
Right.
Okay.
Well, it's not voided. It happened. It just the part of the deal was
okay.
divestment.
It can be, yeah.
Okay.
Right.
Typically, void means it didn't happen.
Okay,
Okay.
Yeah.
So
you and
that's
your
the case.
English.
Well, some of these legal terms start to mean things.
Yeah,
that,
I guess they would.
You know.
But so the brothers could do that if two brothers got together and said, we know mom did this ladybird deed. Give me your interest for a pot of porridge, and sign a quitclaim deed. Voila,
And subject to divestment if mom
subject
changes
to
her mind.
investment. But if when mom dies, then that kicks in.
That is correct.
Even because now remember, quitclaim deeds freak us out, right? Because
not for clearing title.
well, no, but you give all interest you have, if any. Did he have any interest? The answer is, which an hour
Yes.
ago I would have said he didn't have any interest, but he does.
Right. And a quitclaim deed would be the proper way to do it because
That
you
I
can't
did
warrant
not
the
know.
title.
I did not know this,
Yeah. So,
which sort of makes me unhappy.
well, how often does it come up?
Well, actually, not a lot, but enough to where I probably should have known the answer to that question.
Right.
Because I get in my brain that it's just an advanced directive, and that's wrong. That's not really true.
It is seen as an advanced directive.
It's seen
but
as an
special.
advanced directive, but it's not, Rusty.
Well, a will
It
is
is
an
a
advanced
convey-
directive.
Yeah,
But you can change your mind, right?
you can, but the
You still
I
have
don't-
to probate.
I don't think the beneficiaries of a will can be quitclaiming to themselves interest. They ain't going to work.
It's still going to have to go through the probate process and still have to happen. You
That-
know.
Okay, and for those who are listening, I apologize for about what we're about to do here. Sometimes we get in these rants, and I think they only make sense to us.
Well, it makes sense, but you got to keep
listen,
it in
but-
order.
But follow me. Order determining homestead. If you live in the property and you die intestate without a will, property automatically goes to your children.
Unless you have a spouse.
Okay, the spouse is predeceased.
Okay.
No minor kids.
Okay.
Goes
Well,
to your
minor
kids.
kids or not, it's still going to go to your kids.
Okay, goes to your kids, right?
Right.
The kids prior to mom dying cannot be quitclaiming to themselves their inheritance yet.
They don't have anything.
That's right.
And they don't have an interest subject to the investment. They just have an expectation.
They have expectation. You can't be quitclaiming that back and forth. On a ladybird deed, that's different.
Now, you can contract to do it.
On a ladybird, on a ladybird deed, that's different.
That's right. You have,
There's actually a conveyance. It just can be retracted.
it can be
I like that
divested.
word voidable, and I got to get off of it because your interpretation of the word void. it can be retracted,
It can be divested.
divested. We'll use that word, divested. I have to write that word down now. So it can be divested. Okay.
Right.
So in that case, though, a ladybird deed is quite different because they have interest. I didn't realize that.
Right.
I didn't realize that.
So
I was always on the thought of it's mom and dad still owns it 100%. No, they don't.
right.
They actually have a life estate interest. It just can be divested.
No, they have a remainder interest.
They have a remainder interest, right? They can be, but they
Divested.
can divest the interest they've conveyed.
Right. It can be done. Okay. So mom doesn't divest
I learned something new
dead son
today.
of that interest. So what happens when mom dies?
Well, when mom dies with the two brothers, even though the other brother died,
Mm-hmm.
it goes to their heirs.
Goes to that other brother's heirs.
Right, brothers. Yeah,
Okay. There you go.
which makes total sense now. When you first told me about that, it made me think for a tad bit, but it makes
And-
total sense now, especially with the understanding that they have an interest.
Right.
It just can
And
be
could the
divested.
brothers have done a deed between themselves to create a joint tenancy?
Sure,
Mom could have destroyed it.
mom could
could've
destroy it, but they could have done that.
That's right.
Interesting.
Because it is a interest in real estate. Okay. So mom's half of mom interest goes to dead son's estate.
Mm-hmm.
So they have to do a probate.
Right.
And then the other half goes to the surviving son.
That's pretty freaking interesting.
Now, here's the thing that, everybody's all big and nutty about artificial intelligence. Okay. And I have several different tools that I use.
Okay.
One-
Do we even put in the clutch when you did that, or is it about ladybird deeds?
Well, it's
Are
yeah,
you
it's
shifting
about the
gears
it's
without
about
any
the
clutch?
ladybird deeds.
Okay, good.
Okay? I used a prompt, basically the same words. Okay, mom self to A and
Okay.
B or whatever,
Okay.
and
And you put it in different AI?
well, I did it,
platforms?
and I did it in LexisNexis, which is a tool that I use for research,
Right.
a legal research tool. Okay, and it uses its own universe of tools, and doesn't go outside its own tools. It's not going out to the internet or other LLMs to do that. It came back with surviving son gets everything.
Wow.
Okay.
Wow.
Now, both my other tools, and I use Grok and Claude, both of those came back with no, it goes to the dead son's estate for half, and then the live son gets half.
Okay. And that was Grok?
Grok and Claude. Yeah, Grok
and
is
Claude.
Elon Musk's tool,
Right.
and Claude is from Anthropic. The and my LexisNexis tool cited some cases, okay, and even with Lexis being what it is, those cases have nothing to do with this, okay. So, and I originally thought, wow, it's weird
So
that
are you trying to say that Pro Se might not work with AI?
well, that's the point. Okay. But here's the thing. I did that a couple days ago. It gave me that response.
Right.
I did it again today
Is it corrected?
and I corrected
Well,
it.
good. That's good. That's good.
I'm like, what the heck?
No, that's
Okay?
good. That's a good sign.
Now, but the other ones had always been that way.
By the way, we could do a whole show on,
Generative AI.
well, just, Pro Se and AI. And
Yeah.
I know you're dealing with a case like that.
Oh yeah.
Yeah.
And you can tell. So everybody needs to be careful when they do their own brain surgery with AI, because you can get a book on how to do brain surgery, but you're not really going to do that on yourself.
No.
Okay. And I'm not plugging, you need to have an attorney for everything necessarily, because some of these AI tools, if you use them correctly, and that's the point, you got to use them correctly, they can give you some very good information. But most of them say, seek advice of an attorney.
Right.
Don't just take this and run. But it was just weird that the one that I thought would have the best answer was wrong. Now, I changed it for today, but I don't know how, but it did. So, and sometimes it matters where you put a comma in your
I was
prompt.
going to say, did you prompt it any different, or did you put the exact same
It was
query
very
in?
close, okay? And that's the problem.
Mhm.
We're going to talk real quickly. We referenced quitclaim deeds a little earlier,
Yes.
and I am not ever a fan of quitclaim deeds, except for in the case of clearing title issues and things of that nature.
And I agree with you 100%.
Right, because when you sign a quitclaim deed, you're given all interest you have, if any. When you're accepting a quitclaim deed, you're getting all interest they had, if any. Okay.
Well, you understand, we have the Marketable Record Title Act, right?
Right, 30 years, yeah.
Uh-huh. Can it be based upon a quitclaim deed as the root?
Yes.
No.
Yes.
No.
Why?
That's the case law.
Are you sure?
Yeah.
Okay. I don't want to.
Because yeah, it's weird. You can have an unrecorded will, and that
Right.
could be the root of title, but not a quitclaim deed.
I understand. I mean, it's all interest you have, if any, doesn't mean you have any.
That's right.
Right. So, okay. Well, that's
So
probably
just-
better that the MARTA is not based on a quitclaim deed.
Right. That's
So-
just an interesting, when you talk about quitclaim deeds, it does not give you a root of title, which is important for us doing title searches,
Right.
because no interest lasts more than 30 years if there's nothing in between. Okay.
You got to say that again, because I don't
Okay,
necessarily
well-
agree with that statement.
Well, that was a really abbreviated. We
Yeah.
don't care about claims that are 30 years.
If you think you have interest, you have 30 years to say something about it.
That's a good idea. Yeah,
There. I
Okay.
like that. That sounds a little better.
probably. This is why I have to repeat myself in trials and depositions.
Yeah.
Ask the question a different way.
Yeah. Because if you have ownership, your ownership is good until you
Until-
convey that out.
Right.
But if you think you have interest and you felt like you've not been justly dealt with, you got 30 years to try to claim those rights. All right. So you have a story about a quitclaim deed. We have a client we both know that received a quitclaim deed from an attorney of all people.
Oh gosh. Okay.
And right before, and so we're just giving an example of why you don't accept quitclaim deeds. We have a gentleman that he was an attorney and he had a partner of sorts. And we don't need to talk about the details, but the partner was quitclaiming this particular lot or lots to this individual. But right before he gave the quitclaim deed, he gave a mortgage to his wife, right?
Well, so what they had is they had a company.
Right?
Okay. The company was owned by the guy giving the deed. Okay. And
The attorney gave him the deed.
the attorney. Okay. And really, these titles came really from tax deeds. Okay.
Right. They acquired title through tax deed
Right.
auction.
With
right.
my,
Which doesn't,
which is fine.
well, doesn't matter how they acquired it.
But my guy was with my guy's money. Okay.
Right. The guy that got the quitclaim deed.
Yeah. My guy's
yes.
not the attorney. Okay. So my guy's like, I need to get title for these things. I need you to convey them to me. And they talked about it for a long time anyway. So the attorney guy does a deed and, executes it. He also executes a mortgage from the company to himself and his spouse.
Yeah, but the guy that he conveyed the mortgage to, your client, didn't know this.
Well, no,
He didn't know about the mortgage.
Remember, we have a deed from company to my guy and his spouse. Okay.
Right.
Okay.
Your client.
No,
has-
actually, no, to his company. Actually,
Okay,
to my
to your
guy's
client's
company.
company.
My guy's company. So it's from one company to another company.
Right.
Okay. The attorney's company does a mortgage to the attorney and his wife.
Right.
Okay. And
Without
then-
notice to your client.
He didn't tell my client.
No.
My client had no idea.
Right.
And so he executes that, both of them. Okay. With a notary. I
The
know the
notary.
notary.
The attorney did.
Yeah.
Yes.
That notary used to work for us.
Really?
Yeah.
Oh, you have to tell me that.
And then walks across the street. This is Putnam County, and records the mortgage, and then records the deed.
Without notice to your client.
My guy did not know
He
about
thinks
this.
he paid for this property himself.
He paid for the property.
And he's getting this deed thinking that they're dealing justly with each other.
So here's what happens. My guy doesn't know this until I think the deed was done like 2016.
Wow.
Okay. In 2020, a tax deed sale happens on one of my guy's lots. And that's fine because the lot was pretty much underwater. He didn't care. Okay. He buys them in mass. Okay. And you get some good ones, you get some bad ones. It doesn't matter. He makes a claim on the surplus.
And explain what a surplus is.
Okay, when you have a tax deed sale, that's when you haven't paid the taxes for at least 3 years, and somebody who had paid the taxes through a tax certificate makes application to have the clerk sell the property
For the unpaid taxes.
for the unpaid taxes, and that becomes a brand new title.
So, for example, if the auction, if the tax
If the taxes
amount
are 10 grand,
10 grand, but the bid goes up to 20, there's $10,000 left over of surplus that the person who lost the property can claim, or any lien holders can claim.
right. So anybody the people are in line, okay, and the owner who lost the property last, okay. You know, if
Right.
you
So
have
lien holders get their right to claim the surplus first.
right. So if there's a mortgage, if there's a claim of lien for a mechanics lien that's not been paid. Now, municipal liens, there's a different priority there. They have the same, in many cases, same thing or same priority as the taxes. So they get paid first, and maybe they do or do not release their lien. So the person buying the tax deed might be subject to that.
Right.
But my guy makes a claim on the surplus.
Because he thinks he owns it outright.
Right. The attorney for the clerk who does the tax deed sale, who we know, calls my guy up and says, you can't get any of that money because there was a mortgage on the property. And he's like, what mortgage? And he finds out about the mortgage. So we have a mortgage that's recorded and then a deed that's recorded.
Be specific, not just a deed.
It's a quick claim. I don't care if it's a warranty deed.
Listen, I would.
Well,
It changes, Rusty.
It doesn't. It doesn't.
The whole
change the
yeah, it
liability.
does.
No, it doesn't.
It does. Because he warranted the title. He could fall back on those warranties and say, you gave me a deed with a mortgage that you did not disclose to me. So he can make it whole. He has a claim against them.
Okay, that's fine. But
Okay,
but
right?
But that person, that lawyer, has killed himself. Okay, so
I
now
get
what
it, but he still has his wife and the heirs he has to deal with. And they don't know about the
wife
deal.
and the heirs were not part of the transaction.
Exactly. That's why he should have got a warranty deed.
Well,
Because then he could say, where's the disclosure? Subject to what? There's no subject to mortgage here.
there was no closing.
I get it, Rusty, but you understand that they can fall back on the warranties of the deed. The fact he got a quick claim deed, which he knows better.
My guy did not know
Check,
how that happened
man.
before
Check.
it happened. Okay.
You check.
Well,
Yeah, and
remember,
if I said-
this recording happened, and so the attorney, after he recorded, he sent my guy a copy of the deed,
my point is,
but not a copy of the mortgage.
it was a quick claim deed.
That's fine.
And so therefore he's subject to everything. He has no recourse.
There's no recourse.
No, there's no recourse. He loses because he accepted a quick claim deed versus a warranty.
Wait a
Warranty
minute.
deed, he has a case. You could have actually sued.
I might have had a case.
Yeah,
on that
not
issue.
might. You
I
would have had a
a
case.
a different way.
Yeah. Well, okay. What's your case the different way?
Okay.
You're going to have the validity of the deed?
No, what the deed needs to be valid to get.
Well,
my
yeah,
title.
that's my point.
Okay, there's a bunch of other lots there. What determines priority?
Recordation and notice.
Okay, there's a definition of a bona fide purchaser for value, right?
Right?
And nothing is priority to a bona fide purchaser without notice. Right?
Right.
Because we have notice of the taxes, because those are public. We have notice of things that are recorded, and we have notice of what we've been told about before we take the deed.
Mm-hmm.
Right? So far, so good, right?
So far, so good.
Okay. Now, when was that deed delivered? Was there any contingency for delivery of that deed? No. As soon as that attorney made the decision to walk across the street to go record the deed in the mortgage,
Mm-hmm.
that deed's delivered.
I agree.
Okay. At that moment in time, does it matter which gets recorded first? My guy took title as a bona fide purchaser for value. This was not a gift.
Without notice of
And
the
had
mortgage.
no notice of that mortgage. The fact that it was recorded backwards, well, it was recorded backwards on purpose, but that fact does not beat the fact that he had no notice of the mortgage until 4 years later when he went to make, just the recording of the deed first does not change the notice, okay? Because the deed's already delivered. Remember, delivery is kind of
So you're telling me by virtue of the delivery of the deed, the mortgage is void on its face. They had nothing.
not
to
void.
mortgage.
It's just behind the deed. And remember, my guy didn't sign the note.
Right.
There's no debt. There's no way to
What was the order of the recordation? You tell me the deed was recorded first?
no.
The mortgage was recorded first. Yeah.
Of course, it was recorded first.
But because they were the last no, see,
He didn't have notice.
yeah, but that's in a deed situation. When you have deed A, closing A,
No.
and closing B,
Did he have notice of the mortgage?
he did not.
So, modified purchaser for
I
value?
don't know, Rusty. By virtue of recording, he had notice. Public notice.
Before or after the delivery?
He had, the mortgage was executed before delivery of the deed.
So what? Did my guy have notice of the execution of that mortgage?
Did not.
Okay. Goes back to my example that I used that 11 out of 10 attorneys will get wrong. Okay.
Right. About the closings that take place on the same day.
Right. So I go to title company A,
Right.
sell to buyer number 1 at 9 o'clock in the morning.
Right.
Okay. I leave there. I go to
title
land
company B.
title. I go to land title.
Okay, land title.
And sell the same property.
Great. Made me look bad.
No.
Okay.
I sell the same property
Right.
to buyer number 2.
Right.
Okay. I've made a good deal. I've had a good day at closings. Okay. Now I'm a thief. We know that. Okay.
Right.
That's fine. That's at 10 o'clock. So 9 o'clock, title company A, buyer 1. 10 o'clock, land title, buyer number 2. 11 o'clock, title company A records. 12 o'clock, land title records. Who owns the property?
Well, I think by virtue of your order, if it's going to be, it's going to be buyer 1, because buyer 1's deed got recorded before buyer 2. We've done this exercise
There's
before.
a scene in The Godfather where somebody hugs somebody and says you disappointed him, and then he dies. The guy dies somehow
All right,
violently.
No. Okay, let me get this straight. We've got title company. Not you.
know.
So we have title company A, we have buyer 1.
Mm-hmm.
We have title company B and buyer 2.
Okay, and we've got a closing at 9 o'clock,
This is 9 and this
That's
is
a 10.
10. All right.
and then
They record
at 11,
At 11.
at 11
and then you record
And
at
then-
12.
at
Yeah.
12.
Okay, who wins?
B.
Dude, man. No.
I say B.
See, we've done this
Okay.
before.
Did
and
buyer
you got
number 2 know about buyer number 1?
No.
Did he have notice of buyer number 1?
No.
Bonafide purchaser for value without
Right.
notice wins. Now,
But the problem is when the deed gets you're wrong, Rusty. You screwed this up.
no.
You screwed this up. The story is that if they get if buyer 2 gets recorded.
No.
Yes.
No.
You know what? You are 100% wrong because notice is given.
Bet me your drum set.
I really think we talked about this before, and
No,
it was
but
the second recording. I
It is
really do.
It's the second.
It's the buyer
Listen,
2.
the whole question is when does property convey?
No, no.
When-
No,
Hold
no,
on,
no,
no.
What establishes
no.
priority?
Listen, when does property convey?
It conveyed a delivery.
At
Right,
delivery.
at delivery.
Buyer 1's at closing. They got delivery of the deed.
That's right.
Okay.
True.
So they're the owner in theory, right?
For about an hour.
Buyer 2
For an hour.
does not have notice.
Right.
So, okay. Oh, I get it now. Because the recording of the 9 o'clock closing did not
the
take place
hour.
before 10 o'clock.
Right.
It happened the
Gotcha.
hour after.
Yeah,
Right.
half an hour.
Now, if they were recorded at 9:59,
That's different.
If buyer 1 would have had their deed recorded at 9:59 before buyer 2 at 10 o'clock closing, then
buyer 1
Buyer
won.
one wins.
Yes.
it's because the deed was recorded after the closing
Because
at 10 o'clock.
because number 2 had no notice of number 1.
Right.
Okay.
That's right.
Now,
I hate this example.
If buyer 1 would have been at the title company office telling everybody who walked in the door, I just bought this property,
Different.
there's notice.
Right. There's notice.
Right.
Okay. Yeah, because we get stuck in the first one to record wins, and that's a mentality that we have which is not wrong.
Okay, got
But-
you another got
all right.
another example.
I'm gonna have to write this down because
Okay.
when I screwed. But now I do get it now
Okay.
because
I'm
closing.
less disappointed now.
Well, it just took me a sec. I had to see it in black and
It's
black.
like, you know this.
I just forgot about the timing.
Okay.
Okay.
5 brothers inherit
Okay.
mom's property.
5 brothers. All right.
Okay, well, 5 children.
I'll make it brothers. Makes
Okay,
it
5
easy.
brothers. Okay,
5 brothers.
okay. Mom had a reverse mortgage and a shipling.
Okay. So we have a first. Well, we technically have first, second, and third because the reverse mortgage has a first and a second.
Well, fine.
Okay, fine.
Okay. Now, after they get their order determining homestead,
hmm
shipling's or not shipling, but the reverse mortgage is due, right?
Right, because mom's
Okay.
died.
Mom died.
Mhm.
Mom died, so mortgage is due.
Right. Now,
Right. 5 kids now own the property.
and guess what HUD does?
What?
Non-judicial foreclosure.
Right.
Okay. They give notice, we're going to have a auction on day such and such at the property. There's no judge involved.
Right.
Okay, which they can
Crazy
do
power.
under the supremacy clause of the Constitution.
That was another bet I lost, by the way, because when I heard that, I really thought he started smoking crack, and I know he doesn't. But I was officially, you're psycho. There's no way you can have a foreclosure, a non-judicial foreclosure in the state of Florida.
Right.
Won't happen. Well,
Except-
I showed up to the courthouse steps, and this guy drives up in a vehicle from HUD. He steps out of his car, and I guess he gave notice where he's going to be, and he's like, "I'm here for the foreclosure." I mean, like, nobody's listening to him, and he basically 2 people show up, okay, because they got notice of it. He's almost just conducting this auction himself.
And he can.
Yeah, he's just all by himself, you know.
Nobody shows up.
He
too
shows
bad.
up. He's like, okay, highest bidder, me. Okay, good, done. And he goes back in his car. I mean, it's the craziest thing. Had I not gone there and seen it with my own freaking bare eyes, I would not have ever believed it could happen.
Okay.
But I had to go there to see it because I'm like, no, there's no way
Okay.
this happens.
So, what happens is, 3 of the brothers really live at that property. Okay. In fact,
Okay.
they've lived there since before mom died. Okay.
Three lived there.
And some of them, they've had some vacations at the request of the state of Florida at times, but they all live there.
Which means they had orange jumpsuits
Right.
for their
Okay. And so
summer clothing.
they're a friend they met at church.
Okay.
And we're going to lose our property in 9 days. Okay.
Okay, so they go to the friend and say, we're going to lose our property in 9 days because
And
mom's died. We've inherited the property, right?
yeah, we can't do anything because so this mortgage is going to get called and we need help. We'll pay you $500 a month to pay you back. Okay, on a $98,000 rescue. Anyway, so
That's pretty cheap, by the way.
well,
Sure, it's $500.
that's what they said they'd pay.
Okay.
Now, the friend from church who had something to do with the 10 Commandments.
I don't get it.
Well, he also is known as somebody who takes care of a football team. But anyway, I'll tell you later.
Thank you. Thank you for having that
I
look on your
thought
face.
I was tracking, but
Okay,
he
yeah.
threw me.
Oh.
Well,
Oh, okay. Got you. I know it is now.
okay.
Okay,
Oh, yeah.
so
Okay.
he pays off the loan.
I was like,
Okay,
Okay, he pays off the loan.
now
Okay.
he gets a deed from one of the family members,
One of the family
One of the
members.
5.
One of the ones living there or one of the ones not living there?
not living there.
Okay. So
That
one of
person doesn't live there.
they give him a deed
Right.
for their 1/5 interest.
One for the interest,
Okay.
and we're going to say he gets another deed from the other one. He gets a deed from 2 of them. Okay.
Okay. Another one not living there or one
Right.
living there? No. Okay.
Okay.
So he gets another deed.
so
And
the
he-
2 quit claim, basically.
they're quick claims.
Oh,
Okay.
Of course,
But,
because people
just
are
because
freaking
people
do their own
stupid.
deeds.
Because they're cheap.
Now,
They do it.
They're
This is
fast
cheap.
deeds.
They're fast and they're
deeds.
cheap.
That's why I'm doing it. It's a quick claim deed.
Yeah, it's
No,
a quick,
not.
It's a quit.
No, it not. It's
Okay.
a quit claim deed.
Anyway.
now, the 3 brothers ain't signing deeds.
The other 3 are living there.
Yeah,
Like, we live here.
yeah.
We like it.
So we think we're paying you money, or we're going to. They never do, but they're going to. They say. Anyway, Mr. Church guy. Well, let's put it this way. After about 6 months, he decides he tries to evict them. Okay.
Hmm.
because
Well, he's got 2/3 interest.
no, well, he's got 2/5 interest. He's got
That's what
40%.
I meant to say.
Okay, you can't evict a co-tenant, right?
Well, I don't know.
No, you can't. Okay, everybody that owns
If
the
I own,
property. If you own 99% and I own 1%, you can't evict me.
if you live there.
No, you wouldn't be evicting me if I don't live there. So, okay.
What? No, if you live there, I can't evict you.
You cannot evict me.
If you have 1%,
Right.
can't
It's
do
not,
it.
It's
Even
not a voting.
well, and to digress,
if I want to let my
girlfriend lived there.
buddy Peter live there, you can't stop me.
Even though I have 99%,
That's right. It's not a
Okay.
voting. Okay, we don't vote. Now, that's the first thing.
I would have got that wrong. I'm just.
Anyway,
I would have got a lot of things wrong today.
So, the one of the brothers, he prosecutes or he defends this eviction. He gets help from a legal aid attorney. Okay, actually somebody who works for legal aid, and they bring up the fact that hey, we own the property, and Mr. Friend says, well, I've got these 3 deeds that are recorded from each of these guys. I got a deed from each one of these guys.
For the people living there.
Mm-hmm.
Okay.
I got a deed from
So
each,
our
and they're recorded.
friend from the church says, "Hey, legal aid,
I got 5 deeds.
I got 5 deeds."
I've got 5 deeds.
Okay.
Now, the boys, they testify at the trial or the hearings on it and everything. And one of them,
that's pretty important. Did they or
Okay.
did they not?
well, one of them, well, number one of the witnesses to the deed happens to be church guy's daughter, which is not.
That's not a.
It's
doesn't
not.
matter.
It's not. It's relevant, but not dispositive.
It is not relevant.
Well, maybe not.
No, it's not.
Okay. None of them have ever met the notary. They don't know who the notary is. They've never seen that person.
Was the notary there?
None of them.
Okay,
They
how do you
testified-
notarize a document? Well, what does the friend from church say? Was the notary there or not? What
Well,
does
he wasn't part of that. I don't know if he said anything. Point
I mean,
is,
I'd be real
this
interested
case
to
gets
see.
bumped
Well,
from county court to circuit court, and then Mr. Church guy gets tired of this and he sells it to a company.
Whoa.
Okay.
Was there a title insurance company involved?
Yes. Now that company. So we're going
Another
to
reason why you get title insurance.
Well, company buys the property.
There's an active case on this property, and they
Is there less pendings on record?
Was there?
No.
Oh well, then
Well,
okay.
you don't do a less pendings as a defendant in an eviction case, or if you do a counterclaim, maybe you do it. But
Okay.
okay, so
All right.
now the company finds out these guys aren't leaving. Now the
Y'all
the
think?
church guy tells him, "Yeah, I got some holdover tenants, and we're in litigation." And company, they drive by the house, okay, but they don't talk to anybody there, and they take church guy at his word, I guess. And we go into litigation, and I'm defending, and I say,
You're defending all 5 or just the 3?
I'm defending the 3.
Okay, because the other 2, they gave their
they're
deed.
done.
They're done. They don't
They're
care.
done.
There's the 3 living in the house.
Yeah.
Saying they never gave a deed.
Right.
Okay.
And all 3 of them say, look, church guy did everything he could to get us to sign the deed. Okay. He tried one of them. He picked up, took him to get some booze. Okay. Tried to talk him into it. Okay. Came by all the time to do that. Okay. We never signed. We did not sign this deed or these 3 deeds. Okay. I don't know that person. I never met with church guy's daughter. I don't know the other witness. I've never met these people.
And I don't
I
know the
didn't-
notary. Never seen the notary.
I don't know the notary, never seen the notary. Okay. Also,
All right,
one of
well-
them says, I had just gotten out of prison. I have never had a driver's license in my life. And I had lost my prison ID card. There's no way that I showed that notary my driver's license.
Well, what is it? Where's the notary in all this, Rusty?
Don't know.
What do you mean you don't know? That would be a very important
so
witness.
Do you think I'm going to call up the notary or depose the notary and say, I need you to tell me, that you either signed it or you committed a crime. If they're truthful, they're going to say, I plead the fifth, or they're just going to lie and say, I never would do that, right? No notary is going to come to a deposition or to trial and say, I did not see them sign, right? That's my seal. That's my signature. I did not see them sign, right? No notary would ever do that, right? It is a crime. It's a felony to do that. They're going to confess to a felony, right? Nobody would.
I think you'd have to say, all right, where did you do this then? Where did you sign it? Where did you meet them?
Well, you can ask all those questions, and she may have answers, but the point is, no.
Where's her? This guy doesn't have photo ID. What ID did you look at? What did you see? I would like to have her testify to that before we divulge that, hey, he doesn't have an ID.
Right. So
just tell me they won.
Well, here's the thing, though. Did company have notice that those deeds were fraudulent?
No.
Did they have notice then?
No.
Did they have notice that the three brothers had an interest?
Rusty,
or asserting an
you
interest?
know just as well as I that some fraudulent seller out there conveys nothing.
Well, I agree with you.
Okay.
But this person,
so a person's ownership cannot be fraudulently. Well, it can have the appearance. It can look, it can taste, it can smell, but
you can lose the right to challenge that
after 7 years.
No,
what?
That's not the point.
What is the point?
The cases that where it doesn't work, even though a fraudulent deed, a forged deed, is void from the beginning. Okay.
Correct.
All right. It's not voidable. It didn't exist.
Void. It didn't happen.
But if it's homestead, or if it's where you live, it's kind of hard. But if it's investment property,
right?
Okay.
Get to the point.
And I signed the fraudulent deed for you. Okay.
Okay. To Julie.
I signed it to Julie.
Oh, don't bring me into this.
Yes, we're going to bring you.
Okay.
We left you alone all day.
Yeah.
Now
you conveyed
Julie
nothing.
move in. No, you see Julie move in.
Okay, I see Julie move in.
Julie had no notice that there was a fraudulent deed. Okay, you let Julie fix the property up. You do nothing. You just let her do it. And then later on, you raise your head, say,
all right,
thank
but
you.
these three brothers did not sit back and do nothing.
What'd they do? Did they file a less pendens?
Did
they file an affidavit on record?
Rusty, but these are people who don't have any experience or knowledge. They want the legal aid.
Where was that a defense?
Yeah, but they want the legal aid.
Look, if you should hire the wrong attorney. Okay, so here's the deal.
Nothing conveyed, Rusty.
Okay.
No, period.
Did the buyer?
No, it doesn't matter. Doesn't matter. Doesn't matter.
They had notice, Stephen.
What do they have notice of?
Possession is notice.
Of course, I agree with you. So, but you prove my point. Then
they had possession. The buyer did not.
3/5 of this.
If the buyer would have contacted them, okay, and they're at the house a lot of the time, unless they're going to get some beer, okay,
or other things,
Well, they don't have enough money to get other things. But anyway, the point is, if they would have talked to them, first thing out of their mouth was, "Church guy we didn't sign no deed." Okay,
right
now. This closed at a title company. So
the buyers are insured.
So guess who I'm litigating against, though?
Well, the underwriter, which is great.
Right.
That's great. I mean, that's what title insurance is for.
That's exactly what
this is why you don't buy property without title insurance.
And the point is,
problem is there's an exception. They're subject to tenants in possession.
They had an owner's affidavit.
Well, that's on. Oh, I almost said the name. Ooh,
yeah,
almost.
Okay, there was an owner's affidavit. They insured it without exception for that.
Oh, they did?
Yeah. Also, Mr. Church guy, from his closing proceeds, they paid off the ship lien.
Okay.
Which is too bad because that ship lien didn't have to get paid off.
They were still living there.
Right. And if it descends and you would qualify for the ship, you'd be fine. Okay. Right. They also paid off about $8,000 worth of clerk liens for criminal cases for these guys. Okay. That they shouldn't have had to do. And then they, of course, taxes have been paid and they had insurance they had to get. But So the case has not, we just gave our proposed findings of fact and conclusions of law to the court.
Has there been a list pendants filed yet?
Well, there was when the plaintiff, the company, tried to get rid of us, yes.
Okay.
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 But here's the thing.
Try-
This turns on that buyer, that company buyer, had notice. They had at least
Because there's somebody
inquiry
there.
notice.
But I'm going to tell you, Rusty, even if they, well, I guess because people were living there, they should have had notice. So it doesn't work whether or
Yeah.
not they drove by.
What they did,
But-
they tried to come up with, well, yeah, but you guys sat on your rights because you didn't file less pendants, you didn't do this, you didn't do that.
Right.
Well, we were in litigation.
Okay, but if this were a vacant
and
lot,
if
Rusty,
it's a vacant lot,
I'm going to tell you nothing conveyed. You don't know. You know,
I agree with you.
okay?
This is
So,
the first time I've seen that other
defense?
equitable estoppel defense, or not
Right.
defense, it's offense at this point.
Right.
It's the first time I've seen it, but there's case law that supports that theory, but it's limited to nobody's living there.
Right.
You let the person take possession and you know that they're there.
Right.
Okay.
That's a
You
difference.
let them improve
you know,
the property. Then you
I
lose
can
it.
see how you could have some problems there.
Yeah.
All right.
Now, at the end of the day, my people have the 60%, company has
This is a legal aid, by the way.
Oh, yes.
And you're not getting paid.
Of course not. But I get bragging rights when I get done.
Okay.
All right.
You got to beat up a title underwriter.
We'll see. Ain't won yet. But the point is, so company, if I get everything I want, we own 60%, company owns 40.
Well, for the guy who sponsors this show, this is a great lead segue into get title insurance and get title insurance from Land Title of America. Do not have home ownership without an owner's title insurance policy because crap happens. It is expensive to be innocent. It's expensive to be right. And it's freaking expensive when you're wrong, even when it's not your fault. Always get an owner's title insurance policy. Land Title of America, 904-797-9600, 904-797-9600. I'm Steve Collins. We appreciate you listening. Rusty, how do people find you?
904-829-6600.
904-829-6600. He also has a team of another attorney, and he also has an assistant there. They're great, and they'll take good care of you. And we always appreciate Julie being with us and helping us out. Appreciate that, Julie. Thank you for being here. This has been Land Title Talk, and we will see you again soon. Thanks.